Welcome to Raaonline. Today we are going to be talking about legal procedure. Before we get into the actual subject, we will look at some of the common medico-legal terminologies. So what do you mean by forensic or legal medicine? It is the application of medical knowledge to aid in the administration of justice. For example, when you apply the medical knowledge in deciding the cases of injuries, asphyxial deaths, sexual offences, infant deaths, poisoning, so on and so forth. Most commonly, we read in everyday newspapers the cases of sexual offences. There, medical knowledge is applied to understand whether the individual has undergone a sexual assault or not. At the same time, it is essential to identify the accused and identify whether he is capable of performing the sexual offence or not. So, such is the importance of forensic or legal medicine. What is medical jurisprudence? It comes to Latin term juris, which means law, and prudentia, which means knowledge. It deals with the legal responsibilities of the physician with particular reference to those arising from the physician-patient relationship, which means when a doctor is treating a patient or examining a patient, whatever he does with the patient, what are the legal responsibilities of the doctor when he deals with the patient is called as the medical jurisprudence. Coming to medical ethics. Medical ethics deals with the normal principles which should guide members of the medical profession in their dealings with each other, their patients and the state. For instance, if you are discussing about some patient with your colleague, what are the ethics that you should follow with them is called as medical ethics. Similarly, what you should do when you are going to go to the court tomorrow to give evidence or discuss about a case is also medical ethics. How do you deal with patients in emergency? How do you deal with patients' relatives? All this forms a part of medical ethics. Medical etiquette. Medical etiquette deals with the conventional laws of courtesy which are observed between members of the medical profession. So when one doctor is going to talk to another doctor, how do you behave with them? How do you refer a case to them? How do you discuss a case with them? All this comes under medical etiquette. So we are going to be looking at the legal procedure now. Under the legal procedure, we will look at what an inquest is, what are the different types of inquest, and what do you do in the different types of inquest. We will also be looking at the different courts that are there in India and also look at what evidence is and what are the different types of evidence. Further on, we will move on to the procedure to be followed in a courtroom when a doctor goes to give the evidence. So what is an inquest? It is defined as an inquiry into the cause of death, which is clearly not due to natural causes. So death is clearly defined into two types. One is a natural cause or death due to unnatural causes. Natural causes is when the body on its own stops to function regularly as it is supposed to do, which results in the death of the individual. So in those cases, when we are clearly known about the cause of death, we do not conduct an inquest or inquiry. But under unnatural causes such as death which is caused due to a homicide or death which is caused due to suicide or death which is caused due to accident becomes an unnatural cause of death. In general, whenever the cause of death is not known or the cause of death is suspicious, warrants the inquiry into the cause of death. Coming to the types of inquest. Police inquest, magistrate inquest, coroner's inquest, medical examiner system, and procurator fiscal's inquest. Now, this magistrate inquest is divided into executive magistrate inquest and judicial magistrate inquest, difference of which we will be seeing in the future slides. So, to summarize all the types of inquest, we have seen that the police inquest is conducted by a police officer and it is done by under the section of 174 CRPC, which is the Criminal Procedure Code. This is done in India. It is not considered to be a very good one for the following reasons which will be discussed. The executive magistrate inquest, like I said, is done under the section 176(1) of the Criminal Procedure Code and is also done in India. Judicial magistrate inquest is done under section 176(1)(a) of the Criminal Procedure Code and is also done in India. The other three types of inquest, which is the coroner's inquest, procurator fiscal's inquest and the medical examiner system, are not currently followed in India, though the coroner's inquest was conducted once upon a time in Calcutta and Bombay. But currently it is being conducted only in UK, Canada and Australia. The coroner's inquest is conducted by a coroner who is a person who has knowledge in law. The procurator fiscal's inquest is conducted by a procurator fiscal who is similar to a coroner, but this is conducted only in UK or Scotland. Medical examiner system is one who is both legally and medically qualified and is being conducted in the USA. Now, amongst this type, all these types, if you see, the most important in India and the most superior of all the inquests is considered to be the judicial magistrate inquest. This is because the person conducting this inquest is a person who is a judicial magistrate, that is a person who has knowledge in law and who can conduct a trial in the case. So he just not conducts the inquiry but also proceeds to go on to further conduct the inquiry. So in India, the most important or the most superior form of inquest is considered to be the judicial magistrate inquest. But if we look at of all the 6 types, the most important or the most feasible one, if we look at, it will be the medical examiner system, because here the person who's conducting the inquest will be a person who has both medical and legal knowledge. Hence, it is considered to be the most superior system of inquest among all the 6 types of inquest. Coming to the police inquest and the procedure for conducting the police inquest. Now, this is being conducted under section 174 of the Criminal Procedure Code. So, whenever there is a complaint of death where the causes of death is not known or the cause of death is suspicious, a police inquest is conducted. This is the most common type of inquest which is conducted in our country, India. Now, what happens is in this, person will come and complain to the police saying that a body has been found in a suspicious way or the body has been found where the cause of death is not known. Now, this has to be conducted by a police who is not below the rank of a head constable. Once he receives the complaint, a FIR is lodged and the police will make a preliminary inquiry, and the police conducting this preliminary inquiry is called as the investigating officer. Now, before proceeding for inquiry, he has to inform the nearest area magistrate, usually a judicial magistrate. Now, once he goes to the place where the body has been found, he starts conducting his inquiry. He will ask persons who are available around the body, around the area where the body was found, who become the witness in the inquiry list. Now, these people are supposed to answer the questions asked by the police. If not, they will be punished for not answering the questions. So, the persons, normally in earlier days, we used to have the panchayat system. So, hence the terms used were got from that system. So, the police, in the presence of the village heads, who were called as the panchas, because earlier at least a minimum of 5 people were involved, but nowadays a minimum of 2 people who are respectable in that particular area are called for, and the police in their presence will hold the inquiry. He will then conduct the punch witnesses. So, like I said, witnesses who are people in and around that area are called for and they are inquired and they become the punch witnesses. The police will note any injuries found such as abrasions or contusions or the condition of the body, whether it is decomposed, whether the condition of the clothes, whether there were any tears of the clothes or whether there were any stains on the clothes. All these things are noted by the police in their report, along with the identity of the individual, where the police notes 2 identification mark of the individual. He will also write the probable cause of death as perceived by him in that report, and also will write the reports of any evidences which are found around the body. This report, thus prepared by him, along with the signatures of the panchas, is called as the Panchanama or the inquest report.